My name is Bhaskar Mukherjee and আমি সবাইকে নমস্কার জানাই। আমি আসছি কলকাতা থেকে and I am here to present on the topic of the point of Collegium System, the transparency versus autonomy. I'm talking about the challenges that has been faced in balancing independency in the Collegium System. The problems that has come across from various course of times we have witnessed how the term transformative constitutionalism that has been coined multiple times in the Supreme Court, what it actually means, how the interpretation of the constitution is changing from time to time, and how the term consultation that has been mentioned in Article 124 of the constitution that deals with the appointment of the judges, how it got interpreted and how the term transformative constitutionalism put a deep impact on the term consultation, how it later went on to become concurrence. The point of concern over here is that the Constituent Assembly, while discussing, or if I may say so, in the draft constitution in the year 1948, did not mention about independent judiciary. Later on in November 25th and 26th of November 1948, they prescribed about that independency of judiciary is the crux of democracy. If you are talking about separation of power, there has to be independency of judiciary. What it actually means, why it has been included in the restructured company in the case of the Bharti case. There cannot be any kind of influence or any kind of hampering in the independence of the judiciary. They cannot be influenced at any cost. If there is any kind of influence that takes place within the judiciary will fall down, the democracy of the country will fall down, the separation of power will fall down, the rule of law will fall down. So to save from such kind of mishap, the independent judiciary, Article 50, was later on recognized, and in the case of Krishnananda Bharti, it was considered to be a part of basic structure company. Now we are stuck in a paradox. What paradox are we talking about? According to judiciary, that in order to safeguard independency of in order to safeguard the democracy, there has to be an independent judiciary. According to the executive, what is the paradox again? That in order to safeguard democracy, there has to be executive influence in the appointment of the judges of the Supreme Court and High Court. So both sides, they are talking about accountability. One side is talking about independent judiciary, one side is talking about inclusivity of executive influence. Now certainly while discussing about the questions, the paradox that we have mentioned, quickly in very short I will mention about the historical impact that led to this influence of the so while discussing about this particular part, the history, why it actually this independence of the judiciary, how it came into action, or certainly why we are talking about the three judges case. The problem that took place in the 1973, we all know that how Justice A.P. Shah was actually made the Chief Justice of the Supreme Court by bypassing other senior most judges. On the very particular time period, the doctrine of seniority was actually bypassed. At that point of time, suddenly, there was a huge debate that came across that how do we maintain the independence of the judiciary. During that point of time, the first judge's case came in, S.P. Gupta case. In that particular case, it was stated that the executive is superior and judiciary is subordinate. There has to be executive performance, executive inclusivity in the appointment of the judges of the Supreme Court and High Court. And later on, it got overturned in the 1993 landmark judgment, Supreme Court Advocates on Record Association versus Union of India. This 1993 judgment turned, and as I said earlier, transformative constitutionalism paved a huge way for the people of this country, because after all we are talking about the people, we are talking about society, we are talking about the nation. How it actually, this 1993 judgment changed the way, paved the way, by changing the interpretation of the term consultation to concurrence. How? Consultation means how it initially appointed judges of the Supreme Court and are appointed. The president used to appoint the judges. How? Article 74 comes into play. Article 74 clearly states that on the aid and advice of the Prime Minister and Council of Ministers, the President shall act on that aid and advice. So if I may be wrong, but if I say so, that aid and advice can be converted and said direction or command, because the term shall cannot be associated with the term aid and advice. somebody is giving editorial rights. It is up to you whether you want to accept it or not. Though the term shall has been introduced, which makes it mandatory that President has to listen to the Council of Ministers and the Prime Minister. So how the President will appoint the judges of the Supreme Court and High Court? On the influence of the executive, and that is what we have seen in the 1973 situation. But in the case of 1993, it got overturned. Certainly, it said that there will be a birth of the Collegium System, and that Collegium System will be responsible for maintaining the independency of the judiciary. But after the third judge's case, there is a presidential reference, which actually expounded how the judges will be there, how the Collegium will function. There has been multiple backlashes, there has been multiple allegations, and that is why I have come across from Kolkata to here on this auspicious occasion, on this 75 years of the Constitution, the adoption, the enactment of the Constitution, that it aches my heart whenever I listen to any kind of allegation that has been put forward to the judiciary, that how these allegations of nepotism, how these allegations of partiality, how these allegations of, let us say, caste-based, region-based appointments are taking place, how these allegations of relatives, only the kith and kin are appointed. This actually aches my heart, and certainly that is where I come over here to discuss about it. Certainly, the real issue is that whenever these allegations came forth, the judiciary did not take any proper stance. They did not provide any kind of public or press conference regarding the allegations that has been made. All these allegations have been literally throttled away by just giving any kind of interviews in front of the news personals, in front of the media personals. So, just by not taking these allegations seriously, the judiciary is actually breaking its own pillar, because we the people will not be having any faith on the higher judiciary because of these problems. Executive influence is somewhere there. Executive inclusivity is also there. How? Let us say, when the High Court Collegium recommends a name to the Supreme Court Collegium, in between there is a proper scenario of IB that steps in, that is the Intelligence Bureau, who actually checks the character of the judges, who takes the biodata of the judges, how many judgments have been passed, how many judgments have been not been passed, how many delayed judgments have been taking place. So these are the problems that actually came up. These are the situations or discussions that has been taken by the Intelligence Bureau. From the Intelligence Bureau, certain names will be given to the Supreme Court Collegium, hereby appointments will take place. But this particular stage of Intelligence Bureau shows that there is transparency. The government are actually knowing that what are the recommendations that are being given to the Supreme Court Collegium. But actually, when we are actually interpreting the situation, we are witnessing that executive doesn't want just the recommendation. They want to participate in the recommendation. They don't want recommendations to come to them. They want to participate in recommending names to the Supreme Court Collegium based on their own choices. But somewhere or the other, there are problems like RTI. The Supreme Court has clearly stated that in case of collegium discussions, in case of Supreme Court Collegium discussion or High Court Collegium discussion, RTI cannot be filed in any manner. Also, issues regarding the transfer of the judges. I would like to quote 3 instances that I have actually mentioned. The 3 instances are from, in the year 2024, from Chief Justice Prithindra Divakar from Allahabad High Court, who has actually, while farewell speech, he actually stated that a sudden turn of events descended upon me. A sudden turn of events descended upon me when the Chief Justice of India, Deepak Mishra, showered on me some extra affection for reasons still not known to me. Again, the second instance that I would like to portray, Justice Vivek Chaudhary from Calcutta High Court. He had been transferred to the Patna High Court, and he had said during his farewell speech address that his transfer was in the same invincible category as that of mass transfer of judges during the emergency days. He actually took a reference from the emergency days, how the judges were being influenced. Last but not least, the third instance I would like to mention about Justice Sonjeev Banerjee, was the former Chief Justice of Calcutta High Court, then Madras, then was transferred to Meghalaya High Court. He actually stated that I am sure there were cogent reasons for my transfer, but I am not aware of them. I only received an email from GCJI Governor's office. Certainly, these are the statements that has been given in the public forum by the former Chief Justices. Certainly, this puts a question mark on the independence of the judiciary, how this has taken place, and how the backlashes or allegations of the collegium system are put forth. Certainly, there were verbal scuffles between former Union Law Minister Kiren Rijiju and the former Chief Justice of India, regarding the opacity, transparency, lack of transparency, a lot of problems that took place. Certainly, if I would like to mention about the comparative analysis in just 30 seconds. If I talk about Kenya, if I talk about South Africa, if I talk about Britain, if I talk about these countries, Mongolia, they have Judicial Service Commission as well. In comparative analysis, India is the country which is actually different from other countries in case of appointment of the judges, whereby there was an NJSC into situation which was brought forth in the 2014 99 Constitutional Amendment, later on held unconstitutional in the very next year, 2015, by the judgment of Sikora. Somewhere or the other, we are understanding the fact that NJSC or any kind of executive influence in the appointment of the judges is a threat towards independence of the judiciary. Article 50 will be coming into question. If you talk about the recent most matters, while concluding, the recent most matters actually prescribed whereby in various interviews, the former Chief Justice Hidayatullah has mentioned that, but actually these are the news that have been flashed. There are no published information or notice from the Supreme Court that they are actually taking or discussing privately or personally with various judicial officers, various advocates, senior advocates, for the purpose of selecting them as judges. Again, a news that was flashing in this very particular year, 2025 initially and 2024, that the kith and kin of the persons, the relatives of the persons who are there as judges, they will not be considered by the Collegium System. But this is actually again pointing that there are deserving candidates of the kith and kin who might be left out. But they have mentioned that they will be getting fame and money from their practice as well. But the persons who are actually deserving are getting skipped away because of the persons who are being recommended by the relatives in the scenario. I would like to mention and quote one statement from Farias Nariman. He has particularly stated that my client is independence of the judiciary, and we all are here to protect the sanctity of the judiciary, the independence of the judiciary, by prescribing proper timeline of appointment, by prescribing the accountability, how the accountability will be given to the people of this particular country, by prescribing proper names in front of the people why they have been appointed. There are no set criteria for the appointment of the judges. Just as you, Ravi, in an interview with the Wire has clearly mentioned that it is actually an experience-based guesswork that they are doing. There are no set criteria for the appointment of the judges by the Collegium. So this is where I am stepping in. This is where I do not in any way want any kind of allegations against the judiciary. For that I am pleading in this particular forum that throughout this journey of the 75 years of Constitution, the independent judiciary can only be set forth by maintaining accountability, balancing it with independence. Thank you very much, everyone.